Indiana is one of many states that has a mandatory mask order in place, but legal experts disagree on whether the governor has the authority to enforce it. George Hale reports.
Malls, grocery stores, and restaurants in cities like Bloomington have been displaying signs for weeks requiring customers to wear masks to go inside. But it wasn't until late July that Indiana's governor issued a statewide mask mandate. Hours later, the state's attorney general issued a non-binding opinion that the order violated the separation of powers.
According to Attorney General Hill, it seems like the express delegation of authority in that the General Assembly gave the governor when it passed legislation allowing the governor to have these emergency powers would have to specifically mention masks. And that's silly, point blank.
Jody Madera teaches law and medicine at Indiana University's Moore School of Law. She believes Holcomb's order is the type of action that Indiana's emergency powers law was intended to allow.
There's not separate emergency laws to cover different types of emergencies. For example, if we were to have a forest fire, for example, that would threaten part of the state, there isn't a forest fire in emergency law. There's not a pandemic emergency law. It's just a broad grant of authority to handle any emergency that may arise.
The legislative session ended in March, but the Attorney General says lawmakers would need to reconvene at the State House to pass specific laws. Madera says that could put lawmakers and staff at risk. Hill's opinion also focused on penalties. He questions if the governor can unilaterally create penalties and send police to enforce them.
There's some broad, vague wording in the emergency statute that I suppose if push came to shove, maybe the governor would try to say this could be shoehorned under this provision. But I think the better legal argument probably is that the governor actually does not have the power to do this.
Steve Sanders teaches constitutional law at IU's law school. He agrees with the AG that Indiana law doesn't go into enough detail. He thinks that might be why Holcomb later retreated on enforcement, to avoid losing the mandate entirely.
I mean, if somebody had actually been arrested or fined and hauled up in court, then they could have made their argument that this law exceeded the governor's authority, and it, would have been a mess. It could have potentially resulted in his order being struck down. It would have been embarrassing for him. It might have been more dangerous for the state's health.
With many already wearing masks in public, keeping a relatively toothless mandate might help positively reinforce good behavior. And if Holcomb decided to try to enforce the penalties anyway, it might be hard for him to defend them without his AG on board.
The Attorney General's office would be the one that would have to defend it if it were challenged in court. And this is an odd situation where the Attorney General's office has already said basically the governor doesn't have the power to do it.
Jody Madera agrees that Holcomb was acting pragmatically by deciding not to encourage law enforcement to harshly enforce the mandate.
You can either, double down, or you can say, well, okay, I still think it's really important, and I can, in principle, not change much, but I can ease up in my rhetoric. And so I think that's the approach he was taking.
For his part, Holcomb says his order is based on the law and public health. Last week, he said he didn't live under the fear of lawsuits. For Indiana Newsdesk, I'm George Hale.